In September 1855, Abraham Lincoln arrived at a hotel in Cincinnati to work on a patent infringement case. He was tall, wearing trousers that did not reach his ankles, and carrying a blue cotton umbrella. The two lawyers waiting for him, George Harding and Edwin Stanton, were unimpressed. Stanton reportedly turned to Harding and asked why he had brought that long-armed ape onto the case. Stanton would go on to refuse Lincoln any role in the trial. He would also go on to become Lincoln's Secretary of War less than 7 years later. This is the story of McCormick versus Manny, the Reaper patent suit that decided whether one company would control the American agricultural machinery market. Before mechanical reapers existed, harvesting grain required laborers using scythes and sickles, a slow process that left crops vulnerable to weather damage during harvest season. A single reaper could replace the work of several laborers, which made the machines valuable to farmers and made the underlying patents valuable to whoever held them, since a patent determined who could legally manufacture and sell a given design. Cyrus McCormick's family had worked on reaper design since the 1820s. His father, Robert McCormick, spent nearly 3 decades trying to build a workable machine, assisted at points by Joe Anderson, an enslaved man held by the family in Virginia. Cyrus took over the project and was granted a patent on his version on June 21, 1834. The family's finances were further strained by the financial panic of 1837, which nearly forced them into bankruptcy after a business partner withdrew. But Cyrus continued developing and demonstrating the Reaper through the early 1840s. Early sales were slow: 7 machines in 1842, 29 in 1843, and 50 in 1844, all built by hand at the family farm. McCormick received a second patent for Reaper improvements in 1845. After his father's death, in 1847, Cyrus and his brother Leander moved the business to Chicago to take advantage of its rail and water transport links. In 1848, McCormick tried to renew his original patent, but the patent office found that a similar design had already been patented by a rival inventor, Obed Hussey, a few months earlier, and denied the renewal. In 1851, McCormick displayed his Reaper at the Crystal Palace exhibition in London, where it outperformed Hussey's machine in a field trial and won a gold medal. By the early 1850s, McCormick's company was the largest Reaper manufacturer in the United States, selling through a network of trained salesmen who could repair machines in the field during harvest. Patent litigation was common in the Reaper industry during this period, since multiple manufacturers held overlapping patents on similar mechanical components, and McCormick himself had already been involved in more than one such dispute before the Manny case began. John Henry Manny was an inventor based in Rockford, Illinois. He had worked on farm implements with his father before developing his own Reaper design, and he received several patents for improvements to agricultural machinery between 1851 and 1856. In 1853, Manny relocated to Rockford and partnered with local businessmen Sylvester and Wade Talcott to manufacture his machines as J. H. Manny & Company. In 1854, the firm added 2 more partners, Jesse Blinn and Ralph Emerson, and was renamed Manny & Company. That year, the firm built and sold around 1,100 Reapers, and Manny's employees and their families made up roughly 1/10 of Rockford's total population of about 6,700 people. At the Paris Exposition in 1855, Manny's Reaper outperformed McCormick's machine in competitive trials, and between 1855 and 1856, the company manufactured around 6,000 machines. McCormick had instituted the suit in the United States Circuit Court in November 1854, naming Manny's partners individually. The case was formally listed as McCormick versus Talcott et al. McCormick, alleged that Manny's design copied several elements of his own patented Reaper. McCormick sought an injunction to stop Manny's production entirely, and claimed $400,000 in damages. A ruling in McCormick's favor could have ended Manny's company and removed one of McCormick's main domestic competitors from the market. McCormick hired Reverdy Johnson, a former United States Attorney General who would later serve as a United States Senator from Maryland, and Edward Dickerson, a patent attorney from New York known for his work on telegraph and other technology patent cases, to argue his case. Manny's defense was organized by Peter Watson, a Washington patent agent who had originally secured Manny's patents after Illinois politician Elihu Washburn recommended him for the role. Watson, who had previously lived in Rockford, brought in George Harding, a patent attorney from Philadelphia with experience in technical patent cases. Because the trial was originally scheduled to take place in Chicago, Watson also traveled to Springfield in June 1855 to retain Abraham Lincoln, a local lawyer, for a fee of $400, on the basis of his familiarity with the local court and the presiding judge. Lincoln had some personal background in patent matters by this point. In 1849, he had been granted his own patent, number 6469, for a device using inflatable chambers to lift boats over shoals, making him the only United States president before or since to hold a patent in his own name. Lincoln spent the summer of 1855 preparing for the case. He traveled to Rockford in July to meet with Manny and the company's partners, studied the mechanical details of both Reaper designs, and wrote a legal brief. The arrangement was for Harding to argue the technical, scientific points of the case, while Lincoln addressed the judge and jury directly. On September 1st, 1855, Lincoln wrote to Manny and Company noting that he had heard nothing about the case since leaving Chicago in mid-July and asking for an update on the trial date and the evidence being gathered. The trial location was changed from Chicago to Cincinnati, Ohio, where it would begin on September 20th. Harding then hired Edwin Stanton, an attorney from Pittsburgh, to join the defense team. Lincoln was not clearly informed that the change in venue had altered his role on the case. When Lincoln arrived in Cincinnati that September, he encountered Harding and Stanton at their hotel, the Burnett House. Harding later described Lincoln as tall and raw-boned, wearing coarse, ill-fitting clothing with trousers that did not reach his ankles, and holding a blue cotton umbrella with a ball on the handle. Accounts of Stanton's reaction differ slightly in wording, with the remark recorded variously as long-armed ape, long-armed baboon, and long-armed creature, but all versions agree that Stanton objected to Lincoln's presence on the team. Stanton refused to work with Lincoln directly and did not read the brief Lincoln had spent the summer preparing. Part of the explanation was procedural. Custom at the bar limited each side to 2 attorneys actively arguing a case, and with Watson, Harding, and Stanton already filling those roles for the defense, there was no formal place left for Lincoln. He attended the trial in Cincinnati but did not take part in the proceedings. No verbatim transcript of the hotel lobby exchange survives. The account comes primarily from Harding's own later recollections, along with secondhand reports from other lawyers and Cincinnati residents who were present at the trial, which is why different historical sources record slightly different wording for the insult and slightly different details about who was present. Historians including Doris Kearns Goodwin have drawn on these accounts in writing about Lincoln's early legal career and his later relationship with Stanton. The case was heard in federal court before Judges John McLean and Thomas Drummond. McLean was a sitting justice of the United States Supreme Court who, under the circuit court system of the period, also handled trial-level cases in his assigned circuit, which included Ohio and Illinois. Drummond was a federal district judge for Illinois. The court issued its ruling on January 16, 1856, in favor of Manny, rejecting McCormick's infringement claims. McCormick appealed the decision to the United States Supreme Court, which upheld the lower court's ruling. Manny did not live to see the appeal resolved. He had developed tuberculosis during the course of the case and died on the 31st of January, 1856, just 2 weeks after the trial court's verdict, at the age of 30. By 1860, census records listed his widow as owning real estate valued at $150,000 and personal property worth $220,000, a combined estate of roughly $370,000. The defense's total legal costs in the case came to around $60,000. Stanton received a fee of $10,000 for his work. Lincoln received $1,000, which was the largest single fee he had earned in his legal career up to that point. Lincoln was elected president in 1860. By that point, Stanton had already served briefly as United States Attorney General under President James Buchanan in the final months of Buchanan's administration before Lincoln took office. In January 1862, Lincoln appointed Stanton as Secretary of War. Stanton went on to manage the Union's military administration for the remainder of the Civil War and worked closely with Lincoln through the rest of his presidency, a working relationship that stood in contrast to their first meeting in Cincinnati 7 years earlier. Peter Watson, who had organized Manny's defense team in 1855, also joined the War Department under Stanton in 1862, serving as an Assistant Secretary of War and later overseeing the department's Ordnance Office. Stanton was in the room when Lincoln died on April 15, 1865, after being shot the previous evening, and he is commonly credited with the line, "Now he belongs to the ages," although some historians dispute whether he actually said it. Had McCormick won the case, the $400,000 judgment and an injunction against Manny's production could have removed one of his main domestic competitors from the market and strengthened his existing position as the largest reaper manufacturer in the country. Instead, the ruling allowed Manny and Company to continue operating, and competing manufacturers continued producing and improving reapers through the remainder of the decade. McCormick's business was not damaged by the loss. By 1856, his factory was producing more than 4,000 reapers a year. In 1861, McCormick sought a further extension of his original patent from Congress, but the request was denied, while a similar request from Hussey's patent had previously been granted. At the time, McCormick's public opposition to Lincoln and the Republican Party was noted as a possible factor working against him. McCormick's company eventually merged with several competitors in 1902 to form the International Harvester Company, which continued manufacturing agricultural equipment into the 20th century. Manny's own company also continued without him. After his death, the surviving partners renamed the firm Talcott, Emerson and Company, and kept building reapers based on the more than 28 patents Manny had left behind. Ralph Emerson eventually became sole owner of the business, running it as the Emerson Manufacturing Company until 1909, when it merged with another firm to form the Emerson Brantingham Company, which continued producing farm equipment for several more decades. So the verdict did not just preserve one company in the short term. It kept an entire line of competing manufacturers and their patents in business well beyond the 1850s. The McCormick versus Manny case is documented today through the papers of Abraham Lincoln Project, federal court records from the period, and the personal papers of the attorneys and businessmen involved. If you enjoyed this video, subscribe so you'll never miss another episode.